Hey guys, welcome back to the channel. Today we've got a wild one for you. We're diving into the story of a sovereign citizen who found herself on the wrong side of the law, and not for some minor slip-up. This former correctional officer got fired for trying to smuggle drugs into the very jail she worked at. Yeah, you heard that right. Bringing contraband into a correctional facility isn't just bending the rules, it's a major crime. But if that wasn't crazy enough, she's decided to represent herself in court on the day she has to face the consequences. Buckle up, because this is going to get intense. Now, I'm not going to show you the full trial. It stretched on for over 5 hours. But what I have for you today is the most explosive parts. A dramatic moment right in the middle of the trial, and the jaw-dropping conclusion. If you want to catch the full breakdown, my buddy Colin and I are doing a deep dive on his channel this Monday night. Trust me, you won't want to miss it, so make sure you're subbed to his channel for that. Speaking of Colin, let me tell you a quick story. Last year, I was in a fantasy football league with him and a few other content creators, and I dominated that league. Took the championship and left everyone else in the dust. Fantasy sports are one of my hobbies outside of YouTube, and lately I've been turning that hobby into real cash with today's sponsor, PrizePicks. If you don't know, PrizePicks is a daily sports app where you can bet on player stats across all kinds of sports: football, basketball, baseball, even darts and esports. Or as they say in France, cricket. With the basketball playoffs coming, PrizePicks makes it super easy to turn your sports knowledge into cash. The way it works is simple. You just pick whether a player is going to score more or less than their projected stat line. If you guess right, you win. You can even mix and match sports. For example, I can pick Luka Doncic to score more than 29 points, bump that up to 38.5 because I think he's going off, and then switch over to baseball and choose Josh Naylor to have more than a 6.5 hitting score. At the bottom, it shows my final payout. Easy as that. Finalize your lineup, submit, and you're in the game. PrizePicks also gives you stats on previous games so you can make smarter choices. I'm looking at it right now, and I see another solid pick. Nikola Jokic's 50.5 combined points, rebounds, and assists. I'm taking the more on that and pairing it with Luka Doncic's 3.5 three-pointers made. PrizePicks really brings together the thrill of watching sports with the chance to win real money. If you want to try it out, download the app and use code SKEPTIC to get $50 instantly after you play your first $5 lineup. That's code SKEPTIC for $50 instantly. PrizePicks, run your game. All right, with that said, let's get into the trial. We're jumping right into the middle, just after 2 witnesses have testified against this sovereign citizen. She actually believes that one of the next witnesses is part of some grand conspiracy to force her into bringing drugs into the jail. Yeah, it's as wild as it sounds. Let's get started.
And let me move on now. I want to perfect the record just in case it wasn't clear during the bench conference. There was an objection made. Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really.
Yeah,
I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a picture, a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey, Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
Okay, so yes,
Lieutenant Grady.
it's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger, I was in danger, and there was a instance that happened in the car. But I got
I'll be
familiar
honest with you.
from that
I'm still
from
not
that
sure what
situation.
she's
I
talking
found out
about
a couple days
because
after
she
the baby
consistently
shower.
starts.
The judge is allowing her to ask these bizarre questions, but there's just one problem. She doesn't even know who she's talking.
Been the one to do. I don't know who the person was.
Where
but
where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
outside the jail, but I was working with Fulton County at the time.
All right. So the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have any reason to believe that he did?
Because if he's aware of the baby shower,
Oh, no, that's not my question. Not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower, because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from. Anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail, because they have a picture of my son. They have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay. I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next.
Yes.
Okay. Well, glad we're talking about it now then. All right. Well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think
Right.
the state's objection to facts, not in evidence, is one that could very well come again.
Okay.
And we'll see.
Yes, the classic, "that's not my signature" defense. The irony? She admitted to signing an oath of office in the exact same breath. Let's see how well that...
Yeah, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
Yes, Your Honor.
What we'll be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report. And State's Exhibits 23, 24, and 25, which are the GPI lab test results.
Everything else is going to be held back?
Yes, sir.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a
Yeah.
copy of the oath?
If you've already got it, yeah, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office, I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else, not, I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I started working with.
So this is the point where they take a break and come back for closing arguments. Now, pay close attention to what the judge just said. They're taking a 15-minute recess and will be back at 1:50. I want you to remember this, because when they reconvene, only one party shows up, and the other is nowhere to be found.
Is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted, and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, State's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm gonna do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
At this point, the jury is brought in and the prosecution delivers its closing arguments solo. The defendant eventually returns, but only after the jury has left for deliberation.
2:05, it's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, as from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in. and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments?
First of all, it's not the court's job to make sure you show up on time. The judge clearly stated to be back at 1:50, but you didn't return until 4:00 p.m. At that point, the court lost all confidence in your ability to complete the trial without fleeing. As a result, a bench warrant was issued, and she was remanded into custody for the remaining.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag if that's possible. Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Prior Street, which is south of us, and made a left at Mitchell and Prior, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes, Your Honor.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you or did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting reports that you all are calling my mother and
At this point, her sovereign citizen mentality truly began to shine, like the burnt-out light bulb that it is. Now, for those who don't know, courts operate under three main types of jurisdiction: criminal, civil, and equitable. Criminal jurisdiction handles punishments like fines and jail time. Civil jurisdiction deals with monetary damages, and equitable jurisdiction covers non-monetary remedies like injunctions to prevent a builder from constructing on specific property. So there you have it, a quick legal lesson for the day. Now let's see how well she understands any of that.
Put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No,
excuse
it's
me.
not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would
Because
be
you can't deny
no.
that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? An
It's a
amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no and then just reread the intent charge and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice. Your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice. I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done, Ms. Young? Are you done?
No, I'm not. Are you recontracting the
All right.
trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, and you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
And
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Ms. Young. That is an additional 20-day sentence I'm imposing.
you can do as you please because at the end of the day, you have no jurisdiction. You are in contempt of justice.
Please, if you could
and you
please
cannot
escort Ms. Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be here in my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that.
And you know you're in contempt of justice. It's okay. You'll be here for my fee.